Mr. Carlson, if you'd explain the procedures that our jurisdiction developed when it came to absorbing PRCS violations.
I'd be glad to. When we got together in the PRCS Revocation Committee, our main focus was to make the most efficient use of our limited criminal justice resources. My voice is so loud, I don't think I need a microphone. And everybody in the room had to compromise, and compromise is not a four-letter word in Sacramento County. And at the time, the only people that could file petitions for revocation of PRCS was the probation department. And due to AOC requirements at the time, it was quite time-consuming for probation officers to fill out revocation reports. And so one of the things we looked at was, when do we need to have petitions filed? And in the case where a PRCSer was arrested on a new criminal case, and we filed the criminal case, we did not want the probation department to waste officers' time filling out a petition when we had a criminal charge there. If they are aware of technical violations, they would communicate with our office, and we would decide whether or not we wanted to file the technical petition. And when I say technical, I'm talking about a violation of conditions of supervision aside from obey all laws. And usually the general rule was we would not file a technical petition if they're facing a new crime. Now, if they were arrested and we filed cases, our probation department would flash them. And in our county, we consider a flash a custodial violation, thus restarting the one-year period. So there was no need to file a formal petition in those circumstances. After June of 2012, when 1203.2 was amended, and the DA's office acquired the ability to file petitions, we started a PRCS petition in lieu of filing a misdemeanor complaint program. Why give a PRCSer accused of a misdemeanor the right to a jury trial when we can just set it for a hearing before a judge with limited evidentiary standards? If the only basis was a new arrest that they could violate and we did not file the case, it was the general rule that we did not want probation to file the case because we didn't want to use up resources to, in the end, only get 90 actual days, to put on a hearing to get only 90 actual days, though there are exceptions to those rules for public safety. The decision on whether or not to file the technicals is probation's alone, and Mike Bays will talk about that in a bit. Our general process is this: if the probation officer has made the decision that he wants to file a petition, he or she will draft up the petition and go meet with the PRCSer and give what we call an ER, or an early resolution offer. The officer goes with a petition and he goes with an advisement of rights form, and the first thing that occurs is the officer asks the PRCSer if he's willing to waive his right to an attorney and talk about the violation. If he does or she does, they sign the form, and then they have the ability to accept the offer. If they accept the offer, there's a notice of disposition form which is signed and filled out by both the probation officer and the PRCSer, and those forms are then emailed to our court, where they are filed by the court, and then the judgment that was agreed to is entered by the court. If the PRCSer does not want to accept the offer, or he does not want to waive his right to an attorney, then the probation officer files the petition, and that is emailed to the court, and it's also emailed along with a discovery to the public defender's office and the DA's office. There's a standing order in the PRCS cases that upon filing of the petition, the public defender's office is appointed, and the probable cause hearing must be set within 5 court days of the filing of the petition, and those are heard in one home court 2 days a week. At the PCH, or probable cause hearing, the defendant can still, the PRCSer could still accept the offer. If the offer is accepted, then the notice of disposition form is filled out. There's no need to bring the defendant up to go through a plea, and it's given to the court clerk. Case is over. if it is set for a revocation hearing, he has a right to a hearing within 45 calendar days of the filing of the petition. And again, even before the hearing, if all parties, meaning the PD, the PRCS, or the DA sign the notice of disposition form, the case can be settled and taken off calendar with a mere email to the court.
To me, one of the key aspects of what Chris just described was the level of collaboration that goes on between the district attorney's office and the probation department. A strategic decision is made about, is there going to be a new criminal prosecution filed, or is it simply going to go by way of PRCS? And you're not going to do both. You're not going to file both the new criminal charge and put a PRCS violation into play at the same time. Because ultimately a case is only worth so much time, right? And so how you get there doesn't much matter if it makes it more efficient, right? Mike Bays, I'm going to jump over Steve Lewis for just a second. Let me put up on the screen then, Mike. Go for it.